Merci beaucoup, Madame la Présidente, pour me donner la parole. Je voudrais commencer par remercier les organisateurs, nos hôtes, Madame les professeurs Isabelle Bosplatière et Cécile Rapoport, pour m'avoir donné la possibilité de partager mes opinions sur l'application provisoire du CETA. Ouais, je vais faire mon intervention en anglais, malheureusement pour les francophones, mais n'hésitez pas à me poser des questions en français. Je vais probablement répondre en anglais, mais peut-être je vais prendre le risque de me lancer dans une réponse en français. Donc je continue en anglais. My presentation will be about provisional application of CETA, as it has been announced. I have been asked by the organizers to focus on the international dimension of the problem. So I will not touch upon EU law issues that we can perhaps discuss during the question and answers session. In view of the publication, because I understand there is going to be a publication after this conference, I look forward to and welcome any comment you may have. In the course of my presentation, I'm going to draw an extensive analogy with the Energy Charter Treaty, which is an agreement whose provisional application has been the object of a lively debate in recent years and the object also of a couple of investment arbitrations, the most famous of which is, of course, the UCOS case. And due to the affinities, or at least partial affinities between the two agreements, CETA and the Energy Charter Treaty, I think we can draw we can learn the valid lesson from what has happened in the context of the Energy Charter Treaty. So as you can see from my presentation, from the screen, I will tackle three different questions. The first question is actually a simple one, rather than a simple question, is a question to which there is an easy answer in the context of CETA. So the question is, and is a question that has been dealt with extensively by the arbitration tribunal that has adjudicated the UCOS dispute, is whether or not provisional application is mandatory under CETA. Now, in the UCOS interim and interim award on jurisdiction and admissibility, go back, the tribunal established that Article 45, paragraph 1 of the Energy Charter Treaty clearly laid down an obligation for the parties to provisionally apply the agreement in question. So as you can see from the provision in the screen, there are two different clauses concerning provisional application, paragraph 1 and paragraph 2. We will deal with both later during my presentation, but for now, what matters is that the tribunal stated that in accordance with paragraph 1 of this provision, the parties were under an obligation to provisionally apply the Energy Charter Treaty. If we have a look at CETA, as I already mentioned, we will find an easy answer to this question, because the provision, the equivalent provision, the corresponding provision, which is Article 7 of Chapter 30, in particular paragraph 3, A and B of CETA, I think that from the text we can very easily come to the conclusion that provisional application is not mandatory under CETA. So, as you can see, paragraph 3A states that parties may provisionally apply the agreement, and B, that if a party does not intend to provisionally apply a provision of this agreement, it will have to do a number of things, such as notify the other party, and then there will be negotiations on what is going to be actually provisionally applied or not. So the use of may is a clear indication that this is left to the discretion of the parties. This is further confirmed, actually, by a comparison with another similar treaty that the European Union is about to conclude, with the agreement with Singapore that we have already discussed. So if we have a look at the corresponding provision, which is Article 12, paragraph 4, A, B, of Chapter 17 of the EU-Singapore Agreement, so it states that the agreement shall be provisionally applied, on the one hand, and on the other, that in the event that certain provisions cannot be provisionally applied by the parties, a number of things will happen. So in this case, it's clear that the shall most probably lays down an obligation to provisionally apply the agreement, meaning that provisional application under the EU-Singapore agreement is mandatory and automatic once provisional application has been approved in accordance with the respective constitutional internal procedures. So by contrast, the use of softer language, essentially, of a less compelling language in the case of CETA clearly suggests that this is not going to be an issue. And as far as international law is concerned, international law is neutral about this, in the sense that according to the Vienna Convention of Law Treaties, an agreement may or may not be provisionally applied, so the parties can agree otherwise in the agreement, which is precisely what the parties have done in CETA by making this explicit. The second question that I am going to answer, which is partly related to the first, of course, is whether or not partial provisional application is possible, and if yes, under what circumstances. Again, I will refer to the Energy Charter Treaty, where this question has been discussed comprehensively by two arbitral awards that have been rendered under that agreement. So I will go back to Article 45, which is the relevant provision. So it shall be borne in mind that there are two different carve-outs to provisional application under the Energy Charter Treaty. On the one hand, there is paragraph 1, and on the other, there is paragraph 2. So Article 45, paragraph 1 states that each signatory agrees to apply this treaty provisionally to the extent that such provisional application is not inconsistent with its constitution, law, or regulations. However, paragraph 2 further stipulates that notwithstanding paragraph 1, any signatory, when signing the agreement, deliver to the depository a declaration that it is not able to accept provisional application. So in the context of this treaty, it has been discussed rather extensively, as I said, both by the scholarship and by the tribunal, what would be the correct interpretation of this provision. And in particular, two different interpretations have been proposed. On the one hand, it has been proposed that the two provisions should be interpreted conjunctively, and on the other, separately. In favor of the conjunctive interpretation, there has been, in particular, two scholars, Manush Arsanjani and Michael Rasman, who have strongly argued that essentially paragraph 1 qualifies paragraph 2 in the sense that it only authorizes states to issue a declaration that they are not able to provisionally apply the Energy Charter Treaty to the extent that provisional application is incompatible with the national laws. In other words, it will only be possible, according to this interpretation, to exclude that provisional application of the Energy Charter Treaty. It could only be possible to exclude it in case it is inconsistent with national law. Now, this interpretation has not been upheld by the arbitral tribunals, actually in two different cases, not only in UCOS. Both in the Kardasopoulos versus Georgia and UCOS versus Russia, of course, the arbitral tribunal has held, and this is what the tribunal has said in the UCOS case, that nothing in the language of Article 45 suggests that the limitation clause in Article 41, paragraph 1, is dependent on the mandatory making of a declaration under paragraph 2. Now, the similar findings of the two tribunals is unsurprising in the sense that, or perhaps not so surprising, in the sense that the tribunal shared the same chairmanship. So there was the same chairman, who, by the way, was one of the most prominent investment arbitrators, Mr. Yves Fortier, who is a Canadian national. And I think that when the ICC the ICS, the investment court system, will be put in place, he will probably make a good candidate for being one of the judges of the tribunal, or maybe not. I can see some skeptical faces in the audience. But why am I telling you this story about the Energy Charter Treaty? Well, the thing is that after the tribunal excluded that paragraph 1 had to be interpreted in light of paragraph 2, it was left with another problem, as whether or not, under paragraph 1, partial provisional application was possible. And this was because the respondent state, Russia, argued that a provisional application was incompatible with its constitutional law, with its constitution, as long as the settlement of dispute was concerned, because that was a violation of the exclusive jurisdiction of domestic Russian courts. To cut a long story short, the tribunal held that absent any explicit declaration of the parties and any explicit indication in the treaty, Article 45, paragraph 1, had to be interpreted as setting out an all-or-nothing proposition. Put it different, provisional application could only be excluded if provisional application as such was found to be incompatible with the domestic legal order of the state, which is an evidence that is almost impossible to be found because there is no internal legal system, to my knowledge at least, that prohibits provisional application as such. So this is relevant to CETA because if we have a look at the provision again, which will be put in the screen for you, so it indeed gives the parties the right to carve out single provisions of CETA from provisional application. And the reference, the use of this language, if a party does not intend to, clearly again clarifies that this is a discretionary power of the party. However, section 3 of paragraph 3 of this provision, which is the last part that you can see on the screen, I think it clarifies that in principle, provisional application should be intended as referred to the agreement in its entirety, unless the parties agree otherwise by reciprocal notifications. So this seems to me to be a clear reflection of the findings of the UCOS tribunal, because the party have agreed explicitly in the agreement that provisional application would not concern the whole agreement, which is what was suggested by the tribunal in UCOS. However, it is clear from paragraph 3 that it is, in a sense, an all or nothing, unless, so the logic is everything is provisionally applied except what is notified by the parties. So this is the approach that CETA has taken. And it shall be borne in mind that there is, so as I anticipated already in my question during the previous panel, there is some room for arguing that as far as provisional application is concerned, under the terms of the treaty of CETA, there may be only two parties to provisional application. That is to say, Canada on the one hand, and the European Union on the other hand. So the power to carve out provisions from provisional application belongs exclusively on the European side to the European Union and not to the member state. This has a far-reaching consequence, may have a far-reaching consequence as far as the European Union is concerned, because it means that issues falling within the competence of the Union, but also issues falling within the competence of the member states, may be provisionally applied unless explicitly excluded by a formal declaration. In other words, sentences such as this one that we can find in the preamble, recital number 4 of the preamble concerning the provisional application of CETA, so parts of the agreement falling within the competence of the Union may be applied on a provisional basis, pending the completion of the procedures to conclude. And there is another provision in the decision stating that provisional applications shall respect the allocation of competencies between the Union and the Member States. So it seems to me that this kind of statements from an international law perspective would not suffice to exclude from provisional application those provisions that fall within the competence of the Member States, be that exclusive or shared. And why is that so? Because I think that so the internal rules concerning the division of competence, which of course have no relevance internationally, they would probably be captured by Article 46 of the Vienna Convention on the Law of Treaties, concerning which states that essentially the consent to be bound to a party cannot invoke the violation of its internal rule to conclude an agreement unless that violation was manifest and of fundamental importance. And I think that that applies also to provisional application, not only to conclusion. We can probably agree that the division of competence is not, sometimes is not manifest, not even to you lawyers, so let alone for a third country, for the third country concerned. Although this question, of course, so the practical importance of this question may be less important after Opinion 215, because Opinion 215, for two reasons essentially. Well, for one reason, actually. Opinion 215 clarified that the EU-Singapore Agreement, and possibly by analogy also CETA, falls within the exclusive competence of the Union, with the exclusion of portfolio investment and ISDS, and these two parts of the agreement, according to the decision of the Council, would be excluded from provisional application, so that problem will not exist, provided that, of course, these exclusions are notified to the counterpart, to Canada. But also there is practice in the European Union, and in particular, I will refer to the EU-Korea Free Trade Agreement and the EU-Peru-Colombia Free Trade Agreement, in which the Council decision has given provisional application to parts falling within the competence of the member states, showing that if there is political willingness, this problem can be probably resolved at political level. Since I'm running out of time, I only have 5 minutes left, I will address the final question. So the third question, which concerns exclusively the investment chapter of CETA, but this is one of the most controversial chapters, so I think it's probably good to, still useful to have a look at this question, and is what is the effect of the exclusion of the investment court system from provisional application? Now, it goes without saying that the fact that the investment court system will be excluded from provisional application does not mean that investors from both parties will not have rights under CETA. So as far as the substantive standards of CETA would be, of CETA investment chapter, would be provisionally applied, that will give rise to rights for investors of both parties. And when it comes to substantive standards, some substantive standards will apparently, allegedly, be excluded from provisional application. That's the case, for example, of expropriation. But most of substantive standards will not be excluded from provisional application. And, for example, fair and equitable treatment, non-discrimination, and so forth and so on. So those provisions will confer rights, will create obligations among the parties, as far as substantive standards are concerned. However, this is a very well-known provision, is Article 6 of Chapter 30 of the agreement, which essentially states that the party, so the private parties, will not be able to invoke the provisions of the agreement before national courts. So essentially this is a provision that excludes direct effects of CETA. So it means that, on the one hand, the investment court system will not be enforced, because it will not be provisionally applied. On the other, private parties will not be able to invoke the treaty in question before domestic courts. So it looks like they will have rights that will not be enforceable, which is not a completely unique situation in international law. I can think about many situations where there are rights that are difficult to enforce. However, it is not entirely true that they will not have remedies at all. So first of all, as it is actually restated by Article 30.6 of the agreement, we can think about the remedies offered by general international law. And the parties state that, say, all rights other than those created between the parties under public international law. So we can think about remedies such as diplomatic protection in case one of the investors of one of the two parties will be a victim of a breach of its rights under the treaties, and then the two sovereign parties will be able to resort to remedies offered by general international law. But also, I think that there may be another solution. I'm not convinced of this, so I still have to think about it. So really, I would really appreciate your thoughts, your views on this point. So the exclusion of the investment court system from provisional application means that all procedural rules connected, so included in the Chapter 8, will also not be provisionally applied. So, for example, if we have a look at one of the procedural rules, and I have selected one concerning statute of limitation, so laying down a time limit for the investor to bring a claim, and in particular, this is Article 19, paragraph 6b of Chapter 8, which stipulates that an investor must bring a claim no later than 10 years after the date the investor first acquired, or should have first acquired, knowledge of the alleged breach of CETA. So essentially, this provision states that if the violation of the investor right takes place today, then the investor will have 10 years maximum to bring a claim under CETA. So the thing is that this provision is not going to be provisionally applied, while the substantive standards that may give rise to a violation will be provisionally applied. So I think that there might be, as of day one of provisional application, they will enter into force provisionally, so they will be provisionally applied. So I think there might be room for arguing that the exclusion of the ICS may create a situation that is they must be considered equivalent to a sort of suspension of the rights of the procedural rules laid down by the agreement. And as a result, once the agreement will enter into force in a conclusive manner, the 10 years laid down by this rule, but also there are other terms, shorter terms of 3 years, laid down by the previous section of Article 19. So this time will start running as of day one of entry into force. So I think there is some room for arguing that once the agreement will be concluded and there will be the ICS put in place, such ICS will have jurisdiction also on substantive violations that occurred during provisional application. This was all on my part, so thank you for your attention.